The right to a trial by jury was developed in Europe during feudal times. It was transported to England with the Norman Conquest. Then in 1215 it was crystallized in the Magna Carta. The Magna Carta provided, "No free man shall be taken or imprisoned or diseased or exiled or in any way destroyed. Nor will we go upon him or send upon him except by the lawful judgment of his peers or by the law of the land." Despite the historic underpinning and England's strong reliance on jury trials, prior to the American Revolution, the British set about to deprive the colonists of their right to a trial by jury. By 1764, every American colony provided for the right to a jury trial. In the British view, however, those jury trials impeded British enforcement of navigation acts, which laid heavy tariffs on commodities and imposed fines on violators. The revenue flow back to England slowed to a trickle. 1764 assigned the trials of those accused of violating the act to a vice admiralty court in Nova Scotia. It did not matter where the offense occurred. Travel to Nova Scotia was difficult enough in good weather, near impossible during the winter months. The Sugar Act was closely followed by the Stamp Act of 1765. The Stamp Act required revenue stamps be affixed to many kinds of legal papers. A violation of the act could be tried in the vice admiralty courts. The power of the vice admiralty courts thus was extended to cases involving revenue laws with no relevance to maritime commerce. The disputes between the colonists and the British Crown continued to escalate over the next 9 years. In 1774, Great Britain passed the Administration of Justice Act. The act authorized the trial of cases for the collection of revenues be held in Great Britain. Few colonists could afford to travel to London. If they had been arrested and shipped to London for trial, they found themselves without means to hire counsel once they got there. The First Colonial Congress responded directly to the restrictions on the right to a jury trial in the Declaration of Rights in 1774. Our ancestors who first settled these colonies were at the time of their integration from the mother country entitled to all the rights, liberties, and immunities of free and natural-born subjects within the realm of England. The Declaration further stated that the respective colonies are entitled to the common law of England, and especially to the great and inestimable privilege of being tried by the peers of the vicinage according to the course of that law. The Continental Congress described the Sugar Act, Stamp Act, and Administration of Justice Act as grievous acts and measures to which Americans cannot submit. The laws even drew negative comments in the British House of Commons. Several of the colonies issued declarations regarding the right to trial by jury in the local community. Among them were South Carolina, Virginia, and North Carolina. The Declaration of Independence, dated July 4, 1776, included among its list of violations of colonist rights the right to jury trial. The right to a jury trial was again affirmed in the Northwest Ordinance of 1787. The right to a jury trial was the only right secured in all state constitutions subsequent to the Declaration of Independence. The United States Constitution, as originally drafted, however, did not assure the right to trial by jury. This omission was pointed out continually by Patrick Henry and Thomas Jefferson. Patrick Henry spoke to both the right to a jury trial in civil and criminal cases, saying, "How does your trial by jury stand? In civil cases, gone, not sufficiently secured, and in criminal, this best privilege is gone, but we are told that we need not fear, because those in power, being our representatives, will not abuse the power we put in their hands. I am not well versed in history, but I will submit to your recollection whether liberty has been destroyed most often by the licentiousness of the people or by the tyranny of rulers. I imagine, sir, you will find the balance on the side of tyranny." Thomas Jefferson noted the importance of the trial by jury by stating, "I consider trial by jury as the only anchor yet imagined by man by which a government can be held to the principles of its Constitution." Federalists and anti-Federalists agreed to the importance of trial by jury. Alexander Hamilton, a Federalist, stated, "The friends and adversaries of the plan of the convention, if they agree on nothing else, concur at least in the value they set upon the trial by jury. Or if there is any difference between them, it consists in this: the former regarded as a valuable safeguard to liberty, the latter represented as the very palladium of free government." The right to jury trial in criminal and civil cases was guaranteed in the Sixth and Seventh Amendments to the Constitution. The Seventh Amendment states, "In suits of common law where the value in controversy shall exceed $20, the right to trial by jury shall be preserved, and no fact tried to a jury otherwise re-examined in any court of the United States than according to the rules of the common law." Traditionally, the United States Supreme Court has treated the Seventh Amendment as preserving the right of a jury trial in civil cases, as that right existed under English common law at the time that the amendment was adopted in 1791. So, what cases in English common law were tried to a jury? The historical test was first pronounced in 1812 in a decision by Justice Joseph Story in U.S. v. Wonson. While there is debate with respect to whether the Wonson decision has adequate historical support, for 2 centuries now the analysis has rested on which cases in 1791 resulted in jury trials and which did not. The post-revolution historic context includes the fact that during the period of time when the Articles of Confederation ruled the United States, juries created serious obstacles to the new nation's commercial and economic development. Juries often upset long-held commercial expectations by refusing to bring verdicts in favor of British creditors in debt cases or by condemning property owned by allies in numerous cases during the Revolutionary War. Both Federalists and Anti-Federalists were concerned that the new Constitution permitted the federal government to undermine the continuing use of juries. Business interests feared that unrestrained juries would undermine the economic welfare of the nation. The Seventh Amendment may well have been designed to achieve a compromise between those who believed that the jury should have unfettered power to decide both law and fact, and those who sought to allow judges to impose some limits on the jury's power. Fortunately, or unfortunately, the Seventh Amendment did not attempt to define the types of cases in which juries were required or the range of issues which could be put to juries. This was decided by Justice Story in Wonson. The common law of England provided for jury trials and actions to ascertain legal rights, but not for equity or admiralty. Jury trial protection grew over time to reach claims for money damages based not only on common law, but also on statutory law. In Tull v. United States, the Supreme Court developed a 2-pronged analysis for deciding whether a case was within the reach of the Seventh Amendment. The court must examine the nature of the action and the remedy sought. If the action resembles a legal right brought in the early common law courts, then the next step is to examine the remedy sought and determine whether it is legal or equitable in nature. Seventh Amendment law remained dormant for many years until a 1973 case, in which the United States Supreme Court held in a 5-4 vote that rules adopted in the federal district court authorizing juries composed of 6 persons were permissible under the Seventh Amendment. The decision in Culgrove v. Batten says that the framers of the Seventh Amendment were concerned with preserving the right of trial by jury in civil cases rather than the various incidents of trial by jury. For many years, questions have been raised about whether the right to a civil jury trial has been eroded by the federal courts. Directed verdicts, trials by 6 persons, waiver of jury trials, dismissals, and summary judgment have all worked to reduce the check on the judicial branch served by the jury trial. In present-day federal courts, the controversy seems to be over the law-equity distinction, as well as when and how often a summary judgment or a directed verdict may be granted, not whether the line between jury trial and bench trial has been transgressed. The Seventh Amendment has not been incorporated in the Due Process Clause and thus does not generally apply to state courts. However, when a state court is enforcing a federal-created right, of which the right to a trial by jury is a substantial part, the states may not eliminate trial by jury as to one or more elements. It is this historical perspective which leads us to the questions for today. Is the civil jury trial disappearing? Is that bad or good? If we are to save it, how will that be done? And are trial lawyers being trained, and if so, by whom and how?